Creating a North Dakota last will and testament is often more manageable than many imagine. In fact, the document is rather simple to make in most cases, and best of all, it doesn't necessarily involve seeking legal advice from an expensive attorney. In this video, we'll look at the importance of wills and what happens when one isn't made, what's included in wills, legal requirements in North Dakota, and how and where to create an official will. Let's begin by discussing wills and their importance. A last will and testament, better known as a will, allows an individual to put forth instructions on how to distribute their property among beneficiaries upon death. Beneficiaries of a will are usually spouses, children, and blood relatives, but they can be any other person or entity that the maker of the will chooses. It's recommended for all adults to have a will, particularly those of advanced age or with terminal conditions. Now, what occurs if no will is left? A person who passes away without a will essentially loses control of who inherits their property. Instead, North Dakota law determines how the deceased assets are handled. The deceased spouse, children, or blood relatives typically inherit the property by design in such cases. Leaving one's property in the hands of the state can cause loved ones to dispute the decisions made by the courts when distributing the estate, leading to possibly lengthy court trials. Fortunately, all instructions can be documented by making a clear will, and usually without an expensive attorney required. A person of sound mind can draft a will in North Dakota with the following information on the document: their full name and residing address, the information of their personal representative, also known as the executor, who will distribute the assets accordingly, the names of all beneficiaries, and a thorough list of the property each shall receive, any additional terms and conditions, and the signatures of the testator and 2 witness signatures. And finally, let's review legal requirements in North Dakota. Last will and testaments in North Dakota must be signed by the person to whom the will belongs, known as the testator, and 2 or more trusted and competent witnesses, or it can be acknowledged by the testator before a notary public or other individual authorized by law to formally take acknowledgement. Both witnesses must sign within a reasonable time after the testator, although in some cases this time frame requirement can be fulfilled even after the testator's death. And though optional, it's recommended that both witnesses be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or receive a share of the testator's estate. Once all parties have signed, the document will be legally binding. Several copies can be made and given to trusted individuals for safekeeping. We're eForms, the biggest database of legal documents. We have created state-specific last will and testament templates specifically designed for North Dakota that are quick and easy to fill out. Our software generates an official document after you select your desired will instructions and name all of your beneficiaries. Click on the link below to begin creating your will. And don't forget to like and subscribe for more daily videos.